And now I'd like to invite our first speaker, Mr. Alberto HEIMLER. Alberto HEIMLER is Professor of Economics at the Italian School of Government in Rome. He's the chairman of the Working Party on Competition and Regulation of the Competition Committee of the OECD. He was counselor of the Italian Minister for European Affairs, director for research at the Italian Competition Authority, member of the steering group of the ICN and co-chair of a number of ICN working groups. He has been a visiting professor at the Department of Economics at Luis University and University of Rome, Tor Vergata and Bocconi University, and in the School of Law of Haifa University and Tel Aviv University. He has a strong academic background, as you can see, and he has written extensively on antitrust issues, antitrust enforcement, economic regulation, and public procurement, and published in leading journals. The floor is yours, Mr. HEIMLER.
And I would like to thank for the kind invitation Chairman Birol Kühle and Meltem Baj for having put together such an interesting program. Indeed, it is quite rare for labor issues to be discussed in antitrust conferences. So I would like to congratulate the Turkish Competition Authority for the initiative. From what I know, this is the first time that labor issues and antitrust are discussed in a public forum. What is even more interesting today is that although labor market and the digital industry look very distant and very different one from the other, most of the anti-competitive practices that affect the labor markets can also be found in the digital industry, not vice versa, of course, in the sense that the digital economy has additional possible anti-competitive practices that I will only very briefly mention today. In any way, putting digitals and labor together is an excellent idea. And I will refer to some remarks that Lina Khan made yesterday to show how good an idea this was. Certainly, trade unions negotiating collectively the salary of their associated workers do not violate antitrust laws. And this is simply because the workers are not firms, and the legal provisions of most countries specifically refer to firms as the object of those provisions. However, the same person, a lawyer, a surgeon, an engineer, an Italian harbor worker, are firms when they work independently. They are workers, on the other hand, when they work for a salary. So what characterizes a firm in antitrust is not its organization, but the contract which controls the way it supplies its services. And as we all know, this extended notion of what is an enterprise is accepted everywhere and is not an issue to be discussed anymore. We have had many cases against lawyers or engineers or medical doctors. So this is not really an issue. But what I will discuss today is conduct by firms that influences the way they collectively or unilaterally affect the way labor is paid. And indeed, in the introduction, the chair just mentioned this possibility that there are these big companies that may reduce the wage of workers working for them. And in this talk, I refer to a joint research conducted by Daryl Bigger, Alan Fels, and myself. And we wrote two papers on antitrust and the labor market. One was published in the CPI Chronicle, and the other one in a book honoring Eleanor Fox, published by Concurrence. And both papers have been published in 2019, so in a sense, this is quite a recent piece of work. And the point that I'd like to make is that we have to refer to the standard by which we judge whether a practice is an antitrust offense or not. And the problem with monopolistic practices, that is big buyers buying things on the market and reducing the price of what they buy, which affect market upstream, is that they lead to lower prices downstream, because they buy cheap and then they sell also cheaper. And in this way, they make consumers downstream better off, not worse off. And as a result, the consumer welfare standards should welcome monopolies, unless, of course, they become monopolists. And this is why the consumer welfare standard is not really the right approach for understanding buyer power or for analyzing buyer power, because buyer power, unless it leads to monopoly as well by the buyer, should be welcome under a consumer welfare standard. So what should we do to address these issues? And in recent years, there has been increasing support, and Lina Khan is one of the most vocal people that have been promoting this approach. That is, we should go back to the protection of the process of competition, which is where antitrust started, especially in the US with the Sherman Act. And this approach has also a historical tradition in Europe with the ordoliberal school, which views competition law as part of an economic constitution designed to protect economic freedom by ensuring that competitive process and market structure are not distorted. You see, the objective is to avoid distortion of competition. But for an economist, competition should not be considered an end in itself. Competition is a means to an end. The end meaning the welfare of society, or the welfare that in the economy as a whole. And as a result, according to another piece of work I will tell you in a second, in the absence of a central notion of economic welfare, the protection of the competitive process cannot make clear predictions in circumstances where competing economic objectives are placed in conflict. For example, what does it mean protecting the process of competition when we are discussing price discrimination? Should we promote price discrimination or prohibit price discrimination? The same would be, what should we do with an owner of a bottleneck facility? Should they sell at cost to rivals, or is it better for competition to allow a firm to decide with whom and on what terms to deal? Finally, under the protection of the process of competition, what is the maximum price a company may be charged? Those are questions that do not have an answer with such standards. And it may well be that in certain circumstances, the protection of competition standard may provide the right answer, but not in general. And this is why we need a more general approach, a more general solution to this problem. And we found the solution to this. And the solution is to adopt what we call the transaction cost approach to competition law, which was recently developed by Daryl Bigger and myself in a paper which has been recently published by the Journal of Antitrust Enforcement. And the approach starts from the observation that nearly all economic relationships, including labor relationship, as we just heard, will require some form of sunk investment by one or both of the transacting parties. Just to give you an example, for working in an antitrust authority, I need to invest my time and my effort in learning antitrust. This is a sunk investment. However, it is not relationship specific. I can work in an antitrust agency, or I can work in a law firm. I could even choose an international organization or a big company. So it is a sunk investment that cannot be expropriated, because if anyone would try, for example, the agency offering very low wages, which unfortunately happens in many countries, I would switch to somewhere else. A problem, therefore, exists only in such a world if the sunk investment is relationship specific. This means that I do not have any other place to go, and the only employer that can employ people like me can exploit his dominance with respect of me, unless, of course, also I am dominant. And then, as we know, equilibrium is undefined. But anyway, in principle, Only if a firm is dominant, I have no other possibility than to go to this dominant firm, and the firm, of course, has power with respect of me. And the sunk investment of labor supplier, however, is not limited to human capital someone acquired. For example, labor supplier acquires in usual times, fortunately not today, but in most cases requires the physical presence of the labor supplier in a specific city, and most workers would therefore make a sunk investment in a location. They have friends, schools, family networks, sometimes grandparents taking care of the kids. These are all examples of sunk costs that a single employer may exploit at her advantage. Even though the single employer may be a monopolist, of course, there are private arrangements which can offer some protection against the threat of hold-up. A contract, for example, can take into consideration the fact that we are in a long-term relationship, and the contract may put some limit on the possibility of the employer to reduce my wage in the future. Another possible mechanism is vertical integration, and there are a few, not many, labor cooperatives where it is laborers that own the capital equipment. In our paper, we refer to old times, theater companies such as playing companies, which were active at the time of Shakespeare, where the leading actors hire the venues, supporting staff, and partially resolve the hold-up problem without the need for elaborate contracts. As a result of the existence of this sunk cost, what may happen? It may happen that workers may be unwilling to move to a company town because they may be afraid that the company may take advantage of them, or individual would be unwilling to invest in new skills that are too much company specific because they are afraid that the company then may take advantage of them. They would not be able to spend this human capital investment elsewhere. Or a firm on the other side of the market may be unwilling to invest in more productive capacity because they may be concerned that workers would exploit that investment and expropriate that investment, asking for a bigger share of the firm's profits. And according to the transaction cost approach to competition law, a transacting party is in a dominant position or possesses market power if it can engage in hold-up. That is, it's in a position to change the terms and conditions of trade without fear that a transacting party will go elsewhere. And economic harm from the exercise of such market power is the chilling effect on incentives for socially valuable investment. If I am concerned that my effort will be taken away from me, I will not do the effort. In conclusion, the transaction cost approach, as long as upstream suppliers have made material sunk investment, and these are relationship specific, suggest that competition authorities should prevent firms from taking advantage of their position to expropriate the value of the investment upstream. This might include, for example, both the case of a dominant employer, which we just heard in the introduction, lowering wages to employees, or firms in a bottleneck position, like Amazon, for example. This is how the digital issues comes up, taking advantage of its position to exploit the sunk investment of its suppliers. And such cases affecting the labor market do exist. They are rare, but they do exist. They have not come to a conclusion because they were concluded by settlement in the US. But for example, in the state of California versus eBay, the court approved an antitrust settlement shutting down a cartel involving a no-poaching agreement between eBay and Intuit, covering specialized computer engineers, where the two companies agreed not to compete away their engineers one from the other. And the court in the US, through a settlement, so there is not a final decision, prohibited such an agreement. And what the transaction cost approach does is that it also provides an economic standard of harm. And indeed, a practice should be prohibited if it would lead to the expropriation of the relationship-specific investment sufficient to make the sunk investment unprofitable. So that had expropriation been foreseen in advance, I would not have made the effort to study antitrust, or I would not have made the effort to study something firm specific. The transaction cost approach offers benefits over the protection of competitive process standards, because it is based in conventional economic welfare notions and allows for economic welfare trade-offs between different objectives. For example, there's a trade-offs between the need to protect sunk investment by trading partners or sunk investment by the dominant firm itself. And such trade-offs have no resolution under a protection of the competitive process standard. And the transaction cost approach finally allows us to continue to view competition not as an end in itself, but as a mean to an end, which is what we really would like to have. Just leave me 1 minute for a final comment, that is commenting of what Professor Lina Khan said yesterday. She gave an excellent talk identifying practices by digital platforms that may be anti-competitive, but as she also acknowledged, they will not be anti-competitive under a consumer welfare standard, and not, especially in the US, if exploitative abuses are not part of our toolkit. She suggested that we should not have a welfare standard for antitrust, but adopt a much more flexible approach where different disciplines, she mentioned engineering, accounting, finance, economics, law, equity, are mixed together. So this disciplines with no rigor nor with a definite standard. I mean, Daryl Bigger and myself, as we argued in our paper, argue that a better antitrust standard exists, that that standard is coherent with welfare principles, that it could be easily used and addressed most of the questions that Lina Khan mentioned yesterday. And this is the transaction cost standard. So this ends my presentation, and I thank you very much for your attention.
Thank you very much, Mr. Alberto HEIMLER. It was nice to hear from you an alternative approach actually to consumer welfare standard, which dominates usually the US antitrust practice, which was also criticized by Lina Khan, as you mentioned yesterday in our session yesterday. And you presented us the transaction cost approach that was new to many of us, I guess, and it was a nice discovery. I think we will want to learn more about it after your presentation. Thank you very much.